Testing 1, 2. Testing 1, 2. What's up, everybody? Supreme Decisions here, and welcome back to today's episode, or actually tonight's episode. If you are tuning in right now at my time, it's 1 a.m. So I actually want to talk about a couple of things because I've had a call. Actually, I had more than a few calls regarding evictions and even foreclosures in California. Now, if you're a tenant or a homeowner in, how about we cut that off? If you are a tenant or homeowner in California, you need to know about a powerful legal doctrine that can help protect you in court. The California law of habitation, or better known as implied warranty of habitation. Today, we're going to break down what it is, how it works, and how you can use it in both state and federal court to protect your rights. Now, anybody that has been following me for any length of time knows my favorite place to be is federal court because no one wants to go there and very few people can actually maneuver through the federal court proceedings. Now, when people refer to the California law of habitation, they're usually talking about implied warranty of habitation. It's a legal doctrine established by California courts that requires landlords and indirectly property owners to provide and maintain housing that is safe, sanitary, and fit for human habitation. It's not a single statute, but rather a legal right recognized by case law and codified in parts of the California Civil Code and Health and Safety Code. Now, part of that, I'm also going to talk about a separate doctrine which is known by the California Tenant Protection Act of 2019. It is also known as AB 1482. Now, most of us go through this thing and make sure I got the right one. We have very little idea of what it is that's being actually done. But let me switch that out real quick, because this is what I'm talking about right now. In California, a landlord evicts a tenant without the tenant doing anything wrong because they also have the liberty to actually do a literally 30-day increase of the rent, or like non-payment of rent or lease violation. The law requires the landlord to pay the tenant relocation assistance or waive rent as part of the eviction process. Now, there are things that are in place, and this has actually been placed for most rental properties that were built prior to January 1st, 2005. Say that again. If your building is or property is older than 20 years old, you fall under this category, unless there's a specified exemption. And if a landlord wants to evict someone for a no-fault just cause, they must provide location assistance. Now, these are things I'm going to talk about tonight really quick. Now, the first one I'm going to speak about is the implied warranty, because this is one of the ones that we fall under more often than not. Now, how it works. The implied warranty of habitability. It was established by the California Supreme Court in Green versus Superior Court in 1974. It means every residential lease or agreement automatically includes a guarantee that the premises are fit to live in, regardless of what the lease says so. Now, the words fit are open to a wide range of interpretation. Now, I don't even know what this is. A wide range of interpretation. Now, in the midst of that interpretation, it allows for you, the tenant, or even the homeowner, to actually determine what fit actually is. Now, every residential lease, the landlord can waive this obligation even if a tenant signs something saying otherwise. Or excuse me, I said can. The landlords cannot waive this obligation even if the tenant signs something. And what happens is, in California, what they're doing on most cases is they're telling you you have to go to some sort of arbitration. That is false. Just because you sign it does not mean you're obligated to that. And then two, they'll have you saying, okay, well, and even here in Texas, they have you sign an acceptance or intake agreement that the property is livable at the time of lease. That does not mean it remains that way, and that also does not state that there cannot be later issues. Now, the legal sources, because a lot of people, you just talking. California Civil Code, Section 1941 and 1941.1 lists landlords' duty to provide habitable premises, such as roofs, walls, plumbing, heating, electricity, clean and safe grounds. Now, those are just a few, that's not all of them, but those are the most common areas in which there must be safety and livable spaces. Now, under Civil Code 1942, it gives tenants the right to repair and deduct, or in some cases, several cases, withhold rent. Now, this is also something for those that are in Georgia. But again, we're talking about California tonight. It gives tenants the right to repair and deduct. Now, the reason why that's in there is because more often than not, we're talking about an older home, not necessarily apartments. However, there are things that are done in an apartment to kind of make it livable by the tenants, in which you can still do this. Even in Georgia, just to give you an example. I had sent several, it was actually one of my first apartments that me and my, at the time, wife had. And we had made several requests for certain things to be done in the apartment. Excuse me. And the landlord not only was slow, but he just wasn't doing them. So I'm like, you know what? I looked at my watch. I got time today. So I actually went ahead and did a lot of repairs. So then when he came for rent, I politely handed him an invoice. And he was upset, but he could not ask for rent because the repairs, minus labor, I didn't charge him any labor. But the repairs exceeded the rent for like 3 months. So one of the things he then asked me, one, to actually leave. Could you, when this is up, can you leave? Because I was a problem tenant, because I'm not just going to pay you just because you're threatening me. Because you can't even now go to the court and ask them to have me leave. However, I actually did, after I literally waited to the last day of those 3 months and moved out. We found another house. But you can actually do repairs on a property. You have to be compensated for it. But there's also a process into which you need to do that. Because you can't just repair something and then deduct it. You also have to make sure that the landlord is aware that there's an issue before you can start any repairs. All right, now, in severe cases, you can withhold rent. And again, same thing. If you're having a mist of, let's say there's mold, and this is actually happening in maybe 3 of the cases that I've helped with so far. They had mold in the property. They made what do you call that? Complaints about it or work orders. There it is. They actually put together the work orders for it. And the landlord didn't do anything. So what they actually did the mold remediation themselves. Now, mold remediation is wildly vague. However, it's basically taking out sheetrock or taking out certain boards and bleaching everything. That's what they did. And they also did not pay rent. So in that case, the landlord was pissed, wanted them gone, but that actually threw them into the other act, which is the Tenant Protection Act. The landlord had to then cut a check for them to relocate because it was not their fault that he did not or they did not repair the property and make it livable. Because in most cases, that's what's happening. You have these older properties, which, hard to call some 20 years old. But you have these properties in which they're not maintained properly. Let's call it that. Because even whenever I was flipping properties, one of the things we did, we had a checklist. We went down that checklist line by line, and sometimes it's something small that most people overlook. Or if you have a property that was, let's say, they hadn't had a tenant for like 6-8 months, and then now you got a tenant in it, those, because the water's not flowing through there properly or haven't been flowing through there at some time, you're going to have some type of expansion and breakage and leaks that'll occur. Seals will become undone. But it's, again, maintenance issues because the inspections aren't done properly. And this is where I also just spoke about how you're able to also, even if you say, hey, everything's working fine today, does not mean it's working fine 2 weeks from now. And you still have an out and you still have protection. Now, Health and Safety Code, Section 17920.3 and 27920.10 defines what a property substandard is, such again, mold, an infestation, or lack of sanitation. Or infestation actually will be dealing with if you have a bunch of roaches in your house. You have other bugs in your property, even bed bugs. These things, if they're there, those are violations, and they violate in term. You can actually terminate or it violates the. How about I get a drink and get right? It violates the lease agreement that you have with the landlord, and you have legal rights for that. And the usage in state court is the defense against the eviction. You have the unlawful detainer, and a lot of people don't even understand how that actually works. And this is basically if the landlord sues for non-payment of rent, the tenant can argue that the landlord breached the implied warranty of habitation by failing to make necessary repairs. Now, this is one where they, the game is to be sold, not to be told. I'm giving you this because I want you to understand that there is an option. And also, because you will still have to call me because you have to be able to put this in proper sequence with the proper verbiage to defend your case. But there is an opportunity for your case to be defended. Now, the courts have often reduced rent or even dismissed eviction if the conditions are severe. And again, just like we talked about severity, mold, infestation, lack of sanitation, unsafe electrical systems. These things are things that just happen. This is literally happenstance. Now, the affirmative lawsuit for damages. Tenants can sue landlords for damages if they suffer losses, such as medical bills from the mold. And just to give you an example, I actually did not sue my landlord because, for the most part, myself, my wife, my middle son, not my oldest, my middle son, all of us, because of the mold that was in the property, that whenever I did repairs, all three of us had a respiratory, what do you call it? Respiratory infection type deal, which all of us went to the hospital for, and we were all given bronchial dilators, or not, why bronchial dilators? We were given inhalers because we actually all suffer from bronchitis in a minute form. Now, the only reason I didn't was because, again, the landlord was something else, and whole different issue. But it was a reason I didn't sue him, but I had an opportunity to, because there was suffered from the effects of the mold being in the property. Now, you can do this if there is something that you can show. You lose property, you have medical bills, you had time off from work, and those things actually count if you're going to the hospital, if you have multiple appointments for that. All of those things add up, and that goes into a form of pain and suffering. Rent withholding and repair deductions. Tenants may legally withhold rent or deduct repair costs if the landlord ignores repair demands. But you must follow the procedures, because line upon line, precept upon precept, everything you do has a process. So even when you're doing the withholdings, even when you're making the complaints, and whenever you're drawing up the work orders, all of these things have a place, and all of these things have an opportunity for you to actually protect yourself and hold the landlord accountable for. Now, here's the great part about this. Even if you are a homeowner, right, you can use it. This is one that a lot of people don't catch, but again, it's one of those that I spoke about, and it's the homeowners association. Because most people don't understand that the homeowners association not only just guides the community, they also have responsibilities. Now, the homeowners association, if the HOA neglects or negligently cause good God, habitat, your ability to be able to live in the property, or issues, or let's say mold from poorly maintained community areas, homeowners can sue under similar health and safety standards. Basically, if they are in Atlanta, just to give you an example, one of the homeowners associations, and they're actually in court now. They created it was supposed to be like a man-made little fishing area. Well, because of the climate and the vegetation in the area in which they created this little area, it became infested with mosquitoes. So now the common area not only has brought mosquitoes to the community, but there's an infestation in the area in which is supposed to be an accommodation for those living in that community. The HOA is liable for that. They are then going to be responsible for not only one homeowner, but all the homeowners in the area. However, one homeowner, it only takes one to sue. Always understand that. It doesn't take a bunch. You can actually just make it a class action, but one homeowner is actually suing them because they made the common area inhabitable. So, because of the infestation, they are responsible for that. Now, construction defects. Homeowners can use habitability concepts in suits against developers or contractors for defective construction under California Building Codes and Civil Code 896 945.5, the Right to Repair Act. So you have means, even with the HOA, even with your construction company, even with those that you do minor business with. You do have state codes in which you can hold them liable for, and the Right to Repair Act is one of them. Now, my favorite is how to use this in federal court. Federal courts generally don't hear landlord-tenant cases unless there is a federal issue, constitutionality or statutory. But tenants and homeowners can still bring habitability or related claims in federal court under certain circumstances. Now, understand, these are grounds in which are more common than not. There are others. These aren't the only ones. But again, you have a defense. You have an opportunity to not only prepare what it is that you're trying to do and defend your home, you actually have a right to actually be compensated. Now, the civil rights violation, it again falls under 42 USC 1983. If habitability issues involve discrimination, i.e., only certain races or families are denied repairs, tenants can argue violations under the Fair Housing Act, which is 42 USC 3601-3619. Now, this is one that I've only seen once. I haven't had anybody with this issue, but this issue pops up more than any other, believe it or not. And generally it's coming from certain areas. This is pretty much a corporation or property management type deal versus an actual homeowner. So just keep that in mind. Now, Americans with Disability Act claims. If unsafe housing conditions deny accessibility to disabled tenants, claims can be made under the ADA. Now, there's a plethora of reasons why you could fall under inhabitability under ADA. No matter what it is, there's a literal plethora. Now, diversity jurisdiction. Now, this is the flip of it, because this is the switch in federal court. If a landlord and tenant are in a different state and damages exceed $75,000, a court can hear the case. Because remember, when you're filing in federal court, you have to give them jurisdiction over the case. Now, even if the landlord is in a different state and you're suing the property management company, you still file on diversity jurisdiction. But there are other means of getting you to the 75K, in which, that's a conversation to be had during the consultation. Now, substandard housing and federal housing programs. Now, again, even if you're on government housing or Section 8 or other federally subsidized housing is involved, violation of federal housing regulations can be litigated. Now, again, one of those is also an infestation, mold. And you, just because you're on this government program, you still have the ability to be compensated for these things. Because even on these programs, you have to have the right to be able to live healthy for the most part. And you still have a right to be compensated for that. Now, here's the thing. I want you to understand something. The documentation of any of this thing that you're doing is of the utmost importance, because these are things that I would ask you for to make sure you're able to win your case, because that's what you're talking to me for, because you want to win. Now, part of that is going to be documenting the conditions. Now, again, I had a property that I was in here in Texas, and I was paying for the exterminator to come to my apartment because, again, it was an older apartment. They weren't horrible. They just weren't great. But, it was better than the place I was in prior. So the last I want to say last 2 months I was in this property, all of a sudden I had an infestation in my home. So I went and told the property manager multiple times until one day I was in there. Just so happened that the actual owner was in from Austin. And I told them what was going on. Now all of a sudden they didn't want to take my rent, which was cool with me because I used it to move. But they actually had the gall to try to sue me after I moved. What they did not know was I had photos not only of the infestation, but I had photos and video from where they were like, oh, well, you must have a lot of food laying around. I was like, I don't even eat at my apartment. Like, there's literally nothing in my fridge. I buy stuff to drink every night. I eat while I'm at work. I literally go there to sleep. It was so bad, just to understand how little I was at my apartment. I have the GPS programmed in my car, and my car had my job as my residence and my residence as my job because I spent more time at the job than I did at the apartment. So there was no need for me to have food there because when I went there, it was literally just to go to sleep, to get up, to leave again. I spent less time at my apartment than I did at the job. And that was funny. It was actually funny to me because I did that for a year. But now what happened was I get a letter from an attorney and they're saying, okay, if you want to pay off this debt, we're going to do this, we're going to do that. But here's the case number now. But it didn't have anybody's name on it except for the property managers. And I told them, I said, well, whoever's taking the case, y'all just go ahead and notify me. And what I'm going to do is I'm going to add you to the lawsuit. And then I want you guys to request discovery. Because then I can send you videos of this infestation that was in my bathroom. I know y'all didn't know nothing about that. And because I dropped that one, because again, it wasn't just in my kitchen, it wasn't just in my living room, it wasn't just in my bathroom. It had literally taken over one section of my apartment. And it was coming through the vents because what had happened was someone else on a lower floor had a flood. And because we were on a golf course and there was literally bushes after, it was just a whole, they had a bug nest. And during the flood went to the apartment and the apartment wasn't taken care of. They then had an opportunity to then go through the vents to get into other apartments, which was not taken care of because they were not following through, which violated or voided the contract. So which the documentation was the thing that actually saved my behind. Now, send written repair requests to the landlord. I often did that and I made sure I had that in writing so that way they couldn't say I didn't request because every time I noted, I would note what time, how many times I made the request, and I would note the previous days that I've made these requests on. File a complaint with your local code enforcement. Creates an official record. Now, in California, that's a thing that you could do. In Texas, not so much. In Georgia, not so much. You don't have to go to code enforcement. However, you do have to keep a written record of the work order request. Now, that actually sets up your habitability defense if sued for eviction or sue affirmatively for damages. So this again allows you to go for the medical bills and any lost wages and any things of that, any lost property or even damaged property. Now in federal court, you frame habitability issues as a constitutional violation, discrimination claim, or federal housing law violation, or which would actually fall, your ADA will fall under the federal housing law violation. And it'll be 1983 for due process equal protection if the government housing authority is involved. Now, for Fair Housing Act, if repairs are denied in a discriminatory way. Bottom line, for the law habitability, California law is really the implied warranty of habitability. Tenants mainly use it in state court to fight evictions, sue for damages, while federal court claims arise if habitability violations overlap with civil rights. Now remember, you have claims in both places. Each place has a different set of rules for enforcement. And when you're doing that, you must also understand that there are guidelines for that. Because even when we're talking about now the Tenant Protection Act, it applies to most rental properties, again, before January 1st, 2005. Now, if the landlord wants to evict you for no fault, they must provide relocation assistance. No fault includes owner or family member moving into the unit. Because again, what happens is, let's say you're like myself. You're a single bachelor, and then you move your girlfriend in. Or hell, in my case, it'll be my son moving in. He's not on the lease. That is technically a violation of the lease. Now, with that happening, that's one in California in which the landlord will have to pay for relocation or not charge me for the remaining balance on the lease. So that means what he got this month, that's it. You're saying I violated? Okay, cool. Next month, that money goes to someone else because that's my relocation. Now, withdrawing the unit from the rental market, which is called the Ellis Act. So basically, if they say, okay, we're no longer renting this property, they have to pay a relocation fee. That often happens a lot. That also includes if they're doing renovations that require the tenant to leave because there was some type of damage or fire to the property, or compliance with a government order to vacate, which would be if you're living in certain parts of LA where they're having the fires at. And what you need to understand is when we're talking about this, these are not the only guidelines in which you have. They're just the most common. So understand that. Because even if there's a substantial increase in rent, they must, if you're choosing not to pay the increased rent, they must offer you relocation funds. Now, the requirement is 1 month of the tenant's rent based on the rent at the time the notice is given, or waive the tenant's last month of rent. There must be a clearly stated in the termination letter. And if it's not, you have other guidelines for enforcement. Now, there are certain counties that have strong tenant protections. Now, my favorite, because a couple of people have come from these that have gotten these relocation checks, Los Angeles. Relocation assistance can range from a few $1,000s to over $20,000 because, again, the rent in LA is ridiculous. And depending on the tenant's income, age, disability status, and length of tenancy. Again, all of these are different factors that calculate the amount of relocation payment. San Francisco relocation payments are set per tenant, with additional amounts of households with children capped annually. Now, understand that. Let's say you have, I'll use myself. Let's say it was me, my wife, 3 kids, because that's how it was most times. Me and my wife, 3 kids. They would not only have to pay me for the relocation, they would then have to pay my wife. They would then have to pay each child a relocation fee. Now, again, this is something that is done through the courts. This is not going to make, they don't have the right to then put you on the street prior to paying you. Understand that, because I actually had one that attempted to do that. They tried to lock the doors and lock the tenant out of the property. That ended up increasing the amount of money that was landlord was forced to pay. Now, in Oakland, Berkeley, and Santa Monica, each have their own relocation payment rules, often much higher than the state minimum, which again, the state minimum is 1 month's rent. So again, it's going to be a variance because you have an opportunity to fight, and that's what this video is about. You having the ability to fight the eviction. You have the ability to be compensated for actions that go beyond the scope of your ability to even just live, for the most part. Just because someone else wants you out or don't want to make sure where you're living is livable. Now, if no payment is owed, if the eviction is for no fault, i.e. non-payment of rent, illegal activity, or breach of the lease, landlord does not owe relocation money. Say that one more time. If the eviction is for at fault, just cause, the landlord doesn't have to put. Let's say you're arrested. That happens. The landlord doesn't owe relocation. If you do something that breaches the lease that is outside of, let's say, someone else moving into the property, you're not liable. They have to pay you. And let's say you miss several months of rent payments. If you've already missed rent, you are the one that breached the contract and you are then liable. However, there are reasons in which, again, if you miss rent, you can still prove if there have been work orders, if there's been documentation of infestation, anything that's available to you, there must be just cause for you not paying rent. Now, and again, under California state law, landlords must generally pay tenants 1 month's rent or waive it for a non-fault eviction, but in many cities, local ordinances require much higher relocation payments, and sometimes thousands of dollars. Now, understand this. Many people call me because, one, they think I'm cute. Anyway, but no, they call me because they want to know if they even have a case, because that is the first thing before you start spending money, start filing, and start doing all this. Do I have a case that's winnable? So this is what you do the consultations for. And many people that have contacted me, they didn't even understand they had a right to actually fight their eviction, even when it was for non-payment. One, actually, I told him, I was like, hey, yes, you are in the wrong on this one. However, I can help you buy time. And that's generally one of the things that people need. Just a little bit of time to get something moving. You always have options. That is literally the biggest point I want to make from this video. Don't worry about getting stuck and worrying about going on the street. However, you do need to be able to not only just move forward, but you also need to be able to understand that there are options available to you. But waiting is not your friend. So if you're in one of these situations, or you're facing eviction, or you're facing issues with your HOA, the consultation link is up there. The email contact list, email for contact is up there. Actually, it needs to come down a little bit. But you have options. Make the phone call. Holla at your boy. And this is Supreme.